Morning, everyone. As Larry said, I'm going to be talking about recent amendments to the Employment Standards Act as a result of Bill 148 and Bill 47. So to start with Bill 148, this was the Fair Workplaces and Better Jobs Act, which was passed by the previous Kathleen Wynne Liberal government on November 22nd, 2017, about 6 months before the most recent provincial election. Bill 148 introduced a number of new protections for employees, including equal pay for equal work on the basis of employment status. So that meant an employer wasn't allowed to pay a part-time, casual, or worker through a temp agency less than an employee working full-time for the same work. It added a requirement that temporary help agency employees on a long-term assignment were given 1 week's pay in lieu of notice if their assignment was ended early. It introduced new scheduling rules, including an entitlement of an employee to request changes to their schedule or job location after 3 months on the job, permitted employees to refuse work scheduled on short notice, and significantly expanded the 3-hour rule. The 3-hour rule used to be that if an employee showed up to work and were given less than 3 hours of work, they had to be paid either 3 hours of minimum wage or what they actually worked at the regular wage, whichever was greater. So it really was only applicable to employees earning minimum or close to minimum wage. However, Bill 148 expanded the 3-hour rule to require employers to pay the employee 3 hours of the regular wage if they showed up to work, if they were on call and weren't called in, or if their shift was canceled on short notice. Bill 148 also increased an employee's entitlement to vacation after 5 years with the same employer. Formerly, employees were only entitled to 2 weeks, regardless of their length of service. It added in a new leave for domestic or sexual violence, expanded personal emergency leave, including 2 days paid off, and added unpaid leave to take care of critically ill family members. And finally, Bill 148 increased minimum wage to $14 per hour as of January 1st, 2018, and it was scheduled to increase minimum wage again to $15 per hour on January 1st, 2019. However, about 6 months later, after this came into force, Doug Ford was elected Ontario's new premier, and he ran partly on a platform of scaling back the minimum wage and other employment standards changed by Kathleen Wynne's government. Not long after the election, Doug Ford's government passed the Making Ontario Open for Business Act, which received royal assent on November 21st, 2018. This bill made numerous amendments to the Employment Standards Act, and it came into force on the amendments to the Employment Standards Act came into force on January 1st, 2019. Bill 47 scales back some, but not all, of the new provisions which were introduced by Bill 148. So to start with changes that weren't changed by Bill 47. Related employers. If you have multiple legal entities carrying on the same or related business, they're considered a single employer for the purposes of the Employment Standards Act. Bill 47 also retained the additional entitlement to vacation pay after employees work for more than 5 years. It retained the 3-hour rule with respect to shortened shifts, so if an employee shows up to work and they're given less than 3 hours of work, they still have to be paid for 3 hours at the regular wage. And it continued the domestic or sexual violence leave, and employees are given up to 10 days and up to 15 weeks of leave in a calendar year, with the first 5 days being paid and the remainder unpaid. Now moving on to the sections that have been repealed. Bill 47 has repealed the following sections introduced by Bill 148, and they have not been replaced. First, Bill 47 has repealed the right to equal pay for equal work based on employment status, so it is again now permissible for an employer to pay a part-time employee less than a full-time employee for the same work, and the same for employees through temp agencies. It has removed the 3-hour rule with respect to canceled shifts, so if an employee is on call or the shift is canceled on short notice, they're not entitled to 3 hours pay anymore. That rule only applies if the employee actually attends at work. The bill has also removed the employee's right to refuse work. Formerly, an employee had the right to refuse the unscheduled shift if the request was made with less than 96 hours, and now that's been repealed. With respect to minimum wage, under Bill 148, minimum wage was set to $14 per hour and was scheduled to increase again to $15 per hour on January 1st, 2019. Bill 47 has canceled that increase, so the minimum wage is currently at $14 per hour, and it's scheduled to increase annually at the rate of inflation beginning in October 2020. Under Bill 148, misclassifying an employee as a contractor was specifically prohibited, and the bill also introduced a reverse onus on the employer to establish that the complainant was not an employee. So what that means, if an employee made a complaint to the Ministry of Labor and said, I was classified as a contractor but really am an employee, then the employer would have the burden of proof of demonstrating that they weren't misclassified, that they really were a contractor. Under Bill 47, it's still prohibited to misclassify an employee, but the reverse onus has been removed. So what that means is that it's now, again, if an employee makes a complaint or if an individual makes a complaint, they still have the burden of proving that they actually were an employee, not a contractor. So practically what that means is in cases where it's a close call, the Employment Standards Officer is going to be more likely to side with the employer than they would previously. Bill 148 changed the public holiday pay formula. Before Bill 148, the way you calculated holiday pay for a stat holiday is you took the total wages and vacation pay earned in the previous 4 weeks, divided it by 20, and that was your pay for the public holiday pay. Bill 148 changed that to take the total wages earned in the immediately preceding pay period and then divide that by the number of days actually worked, and that was the public holiday pay. I know at first glance that change doesn't seem very significant, and in lots of cases it would result in employees being paid the same amount, but a number of employers became very upset because in certain circumstances for part-time or casual employees it resulted in them being paid significantly more under the Bill 148 formula. And just to give an example, if you had a part-time employee who was working 5 days a week, half days, then under both the old formula and the new formula, they'd be paid half days pay on the stat holiday. However, if you had an employee who worked 1 day a week, but they worked a full day, under the new formula, they'd actually have to be paid an entire day of stat holiday pay, even though they're actually working less hours per week than the employee working half day, 5 days a week. So a lot of employers are upset about that, and from a policy perspective, it didn't really make sense. So that change was repealed by Bill 47, and now we're back to the old formula. Under Bill 148, employees were provided with 10 days of personal emergency leave, with the first 2 days of the leave being paid. Under Bill 47, this paid leave was repealed, and it was replaced with unpaid leave entitlements split into 3 categories: sick leave for up to 3 days, family responsibility leave for up to 3 days, and bereavement leave for up to 2 days. If an employee takes a leave under the Employment Standards Act, the employer has the right to request evidence reasonable in the circumstances to justify the employee's entitlement to the leave. However, under Bill 148, employers were specifically prohibited from requiring a doctor's note to justify an employee's leave. Under Bill 47, that prohibition has been removed. So an employer is once again entitled to request a doctor's note to justify a leave, if that will be reasonable in the circumstances. Bill 148 increased the fines for contravening the Employment Standards Act. The fine was $350 for a first contravention, $700 for a second contravention, and $1,500 for a third contravention. Bill 47 has reduced the fines to the pre-Bill 148 amounts. So now the fines are $250, $500, and $1,000 for first, second, and third contraventions respectively. And I should note that if the contravention impacted multiple employees, the fine would be multiplied by the number of employees affected. So for example, if there was 10 employees who were misclassified as contractors, then the fine would be multiplied by 10. So that's all the changes. So just to summarize what I've gone through in the current state of the law, separate legal entities carrying on associated or related activities or businesses are now treated as one employer. An employee is entitled to 3 weeks of paid vacation after 5 years of employment, formerly it only being 2 weeks regardless of the length of service. Employees must be paid for 3 hours if they tend to work, but not if they're on call or the shift is canceled on short notice. The right to equal pay for equal work based on differences in employment status has been repealed. The right to refuse work on short notice has been repealed. The minimum wage remains at $14 an hour, and is scheduled to increase annually at the rate of inflation. The public holiday pay calculation has been changed and reverted to the pre-Bill 148 formula. Employees are now entitled to domestic or sexual violence leave. They have the paid personal emergency leave has been repealed and replaced with unpaid sick leave, family responsibility leave, and bereavement leave. The prohibition on employers requesting a doctor's note to justify a leave has been removed. The reverse onus placed on employer with respect to misclassifying an employee has been repealed, and the fines for contravening the Employment Standards Act have been reduced to the pre-Bill 148 amounts. So that is the end of my presentation. Thank you for listening. The next speaker will be Marty Rabinovich to talk about termination clauses.